Welcome everyone to this webinar. I'm your host, Bilal, and I've got three very special guests joining me today. First of all, we've got the former chair of the UK Health and Safety Executive and lead of the independent review of the Grenfell Tower tragedy after it happened, culminating in the Building a Safer Future report, and that is Dame Judith Hackitt. Joining her, we have the UK's leading fire safety lawyer, Warren Spencer. He has prosecuted and defended fire safety cases for over 20 years. And as a higher courts advocate, which is an accreditation which enables him to work as an advocate in the Crown Court, he's seen a lot of fire safety cases in his life. He's also a part-time tribunal judge and a former assistant deputy coroner. So a lot of questions for him later down in this webinar. We've also got TO's very own fire safety service engineer veteran, which is Jason Hill. He has visited thousands of buildings in his 20-year career. He's looked at, installed, reviewed, maintained fire safety systems for all types of buildings and trained people how to use them and how not to use them. He's seen it all when it comes to how people manage their fire safety, and from the best of the best to the worst of the worst, he's got a story for everything. And this webinar is about advancing fire safety. So with our three special guests, we're going to be looking at the regulatory reforms and the culture that led to the government needing to change those rules and why the government changed those rules. Really think about issues such as ignorance, indifference, lack of clarity, and how hopefully the rule changes will be impacting and improving those situations. We've also got the legal perspective with Warren Spencer. So how are those rules and regulations actually enforced? Who gets impacted? Who's involved? Who's targeted? And why do they approach things in the way that they do in different scenarios? So we want to really share how you can navigate that as a building occupier, a responsible person, employee, employer, landlord, tenant, all of that. We're going to help you put the best foot forward when you get a knock at the door or a letter in the mail. And finally, with Jason, we're going to round it off with real practical advice on how to take all the information you've got in this webinar and level up your fire safety compliance and take control of the fire safety compliance in your buildings and across your teams, whether you're a one-person team or responsible for the safety of 1,000 people. And for myself, I'm going to be in the live chat chatting with you. So if you are really interested in us covering a certain topic or asking a question you want one of our experts to answer, leave it in there and we'll try and answer it live. Without further ado, I'm going to hand over to our guests.
Okay, well, thank you. And hello, everyone. Thank you very much for the opportunity to join and speak at this webinar today. You've asked me to speak about the regulatory process and the new framework, which will be fully up and running in April. And I will do some of that. I'll refer to the new regime, its requirements, and so on. But what I do want to start by doing is just recapping on why we're here and why we all need to think and act very differently going forward. There's no doubt the new regulatory framework is there to drive that change of mindset and new behaviours, but it is not the reason why we are doing it. Following the tragic fire at Grenfell Tower in June 2017, I conducted, as you heard, a review of fire safety and building regulations. And what I found was a system that was completely broken. Despite the many new priorities and challenges which have come along since then, I completed my report in May 2018, and from then on, I've stayed focused on driving change across the whole system, not just to the regulation. And I want to say a little bit more about why that is. Quite simply, because I was shocked at what I found. Not just a regulatory system itself that was weak and ineffective with little or no enforcement, but an industry that saw this weak regime as an opportunity for a race to the bottom because they could get away with it. There were conflicts of interest everywhere I looked. The discipline in ensuring that what was designed got built simply wasn't there. And record keeping in construction, occupation, refurbishment was poor to non-existent. There was substitution of products with little or no regard for fitness for purpose everywhere I looked. There's a lack of competence in most of the disciplines involved. And perhaps most shocking of all, lots of people knew about these widespread practices. I didn't uncover and surprise people, they already knew. But no one felt a sense of ownership and responsibility for fixing it, which is why I use words like indifference in my report. It was this wholly broken system which led to the tragic loss of life at Grenfell Tower and to the subsequent discovery of many other buildings with defects and poor safety systems. The greatest failing of all is the failure to care about the safety of the residents in the buildings we construct and maintain in occupation, especially when these residents are in multiple occupancy, high-rise buildings where they rely on others to ensure their safety throughout the life cycle of the building. That is why we are here today, to discuss how we rebuild trust and confidence and how we step up to our moral duty to ensure residents' safety, not simply to understand how we meet the requirements of the law. As far as the regulation itself is concerned, I hope that by now you are becoming aware of the key elements. We will have a new regime that seeks to ensure buildings are designed to be safe and are then built as they are intended to be built. That philosophy will continue throughout the life cycle of the building to ensure that resident safety is maintained and can be demonstrated throughout the life of the building. But it's also important to recognise that this new regime is designed to be proportionate. Greater levels of attention and demonstration of safety will be required for higher risk buildings than those that are there for single occupancy by an individual or a family. Regulators and residents in this new system will want to see evidence of how safety is being managed and monitored. And it makes sense to use digital technology to help wherever possible, rather than reverting to bureaucratic record keeping. I want to share one slide as part of this presentation, and it is to try and help everyone to understand that however small your part in this process, it matters. The model you see in front of you now is what engineers in many different parts of whether it's chemicals, oil and gas, or now in the building sector look at as what we call the Swiss cheese model. It's meant to indicate that for any system to be safe, you never ever rely on one simple means to act as a barrier between you and bad things happening. The whole idea is that every one of those layers really matter because they are part of a system of different means of defense or barriers or safeguards. And because we expect every one of them to develop faults or glitches over the course of a lifetime, the more of those that you have, the better protected the building or the chemical plant or the oil rig will be. So this whole idea of multiple layers really does give meaning to why, whether you're the person installing the fire detection system, or whether you're the person installing the fiber optic cable, and you need to remember to get the fire stopping back in place and not just leave holes in the buildings or whatever it is, every one of those layers of integrity in a building really matter. So we can take that slide down now, but I'd like you to keep that image in your mind going forward. So that's why we need behaviour change. We need people to focus on demonstrating safety and fitness for purpose of buildings and keeping that mindset throughout occupation. The safety case approach, which you will have heard about, is there for people to demonstrate that you've thought about what might happen, what might go wrong, and the measures you have in place to provide that protection. We need the whole supply chain to collaborate, to share data, to improve their record keeping, standardize their systems, and focus on delivering that reliability. But what I'd also say is keep it simple. Don't be overwhelmed. This is not an enormous task. It really isn't that difficult. Dare I even suggest that it's what you should always have been doing anyway. I think it's particularly important in this new regime to take this proportionate and pragmatic approach, especially to existing buildings. Yes, you do need to find out what you have, and you may discover that there are shortcomings. By all means, and indeed do make improvements if they are affordable and they are justified. But focus on what improves the overall integrity and safety of the building. Get good, sensible, proportionate advice, and above all, involve residents in that process of deciding how and what changes are going to be made to the building. This is a dynamic and moving process. Buildings and their risks will continue to change over time as we introduce new risks through new technologies and so on into buildings. So it's a process that has to be kept going. Do approach this new regime with confidence. Don't be afraid of it. Do what's right for the right reasons. The regulation is actually there to drive and encourage the right behaviours as much as it is to hold to account those who ignore their responsibilities. Thank you.
Thanks, Judith. That was brilliant. I was just going to add that there's lots of really helpful guidance on the government website as well. That's really clear and easy to understand. So like you said earlier, don't be scared of this. It's not complicated. I think all the guides that have been written by the Home Office, and we can share some links to the audience of those documents, are actually really easy to understand and follow. So great job on those documents.
I think your emphasis on the pragmatic approach, like the model of the Swiss cheese, shows that everyone at every level of a building's life cycle has a responsibility to play.
Yep.
And so we can never really pass the buck to the next person in the process, or the person who was in the process one step before us.
That's true, but I think it's also important for people to recognise how important their bit is. You know, people often think, well, what I do doesn't matter. It doesn't make any difference. Yes, it does. The smallest things can damage the integrity of the building. So do whatever you do and do it well. Absolutely.
And I see this on a daily basis, Judith. For being an ex-engineer, unfortunately, I'm cursed with eyes that look, and the amount of buildings I go into where the fire alarm panel is lit up like a Christmas tree. And it's probably because the end user hasn't been doing their regular checks. They're relying on the 6 monthly visit from the engineer. And like you say, although a daily check of a panel doesn't seem important, actually it does have a vital role to play.
Absolutely.
So I completely agree.
The last thing you want is the 6 monthly check or the infrequent check of a fire extinguisher to give you confidence that it's still available 5 months and a half after the last time it was checked. And you really want to make sure that those things are checked on a regular basis if somebody in your company or your organization has that responsibility. Warren, what do you think about the enforcement side of those regulations? Dame Judith has made the point actually really helpfully that it's not just about a fear factor that the rules have now changed. It's actually an encouragement to make sure that you're doing best practices, but the enforcement still exists.
The enforcement does exist, and certainly I think we need to make a distinction between the construction side, where there are no occupants, and then the management of the premises where after occupancy has taken place. Because I've had in the last 5 years numerous cases where buildings have been built since 2009, for example, and a good example is PFI buildings, where all of the things that Dame Judith was concerned about in her report were existing as recently as 2010, which, bearing in mind the fire safety order, for example, came in 2006, worries me about future compliance, and so the fire safety order has limited application to the construction phase, but total application following occupancy. And what I've found in cases that I've dealt with is, one, there's been a lack of accountability from those responsible for construction and design, and the opposite of what we hope for in the future, which is that everybody will do their bit. In fact, the tendency has been to blame whoever went before you. So I have had cases where the clerks to the works blame the construction company, building control blame the clerks to the works, and the management company blame the construction company. Very often the management company is a subsidiary of the construction company, and so what I've seen is a blame culture and a lack of accountability of people saying, yeah, that was our part, and we've not done it very well. Going forward, the building safety Act, I think, will have some significant effect, and it will, provided people comply with it, it will deal with the accountability issues, and clearly my slides are headed "The Need to Manage and Record," and it's about that management, and not just tick box exercises, which I see time and time again. I see companies and people with the right frameworks in place, but without the accountability with regard to detail of implementation of those policies and procedures. And so I agree that it should be simple. It's simply about doing your part, your part of the golden thread, to quote another part. But my experience has not filled me with a lot of hope.
Yeah, and I share similar concerns. You know, I've seen buildings that have been built to a really high standard, you know, and then it's handed over to the end user or the occupant, and they completely destroy the building. Like Dame Judith said earlier, you know, you've got telecoms engineers that don't really understand fire safety, drilling cables through walls, breaking down compartmentation. You've got people propping fire doors open with extinguishers, which then damages the door, it damages the firefighting equipment. So the Swiss cheese model encapsulates it beautifully. It's all about all elements from handover all the way through. You need to continue to maintain that building to a high standard. Otherwise, if it's been built to a high standard and we've raised the bar there, it just slowly starts to drop as the building gets older. So I share that concern as well.
And Warren, this actually is encapsulated in a concept I think you pioneered, which is the matrix of responsibility. Could you tell us more about that?
Well, I don't want to take credit for Matrix's responsibilities, but that's I don't think my invention. My suggestion that it might apply to the management of fire safety, again, I'm not sure it was my invention, but it's something I've suggested. Where there are numerous parties who are responsible for the management of premises, the most common question I get asked by telephone calls and in conferences is, who's responsible for this, Warren? And I say, well, it should be in your documentation. The reality is documentation does not include responsibilities for fire safeties. In fact, I very recently dealt with a very large organisation who still thought that this clause from 1925, that the tenant is responsible for compliance with all legislation, still exists. And quite clearly that does not exist as far as the fire safety order is concerned, because the fire safety order says where you have control of premises, you are liable to the extent of that control. So there's that confusion about who is responsible for what part, and the matrix of responsibilities can clarify that without having to go to amend leases that may be for 25 years or leases that have been in place and still have 10 years to run. So instead of having to go through the process, especially in companies which have numerous premises and numerous stakeholders, instead of going through the whole process of changing the original documents, let's all agree on a matrix of responsibilities to attach to those documents. And that seems to me to be a simple approach where everybody is clear on what their responsibilities are.
Yeah.
And speaking of, that's something people can do today.
Absolutely.
If you don't have this.
Where I've suggested that this approach, the immediate response is very often being, I'm not sure that we'll be able to persuade our partners, stakeholders to agree to this. And I said, well, you won't know until you try. And then when I go back, the answer is actually they welcomed it because they wanted to know which bits they were responsible for, so that they could own that and they could have accountability for that, and the clarity was welcomed. So, oh, do you know what? We know now what we've got to do, and we'll do it. And when I've gone back, the problems that have arisen have been minor in nature and few and far between. So, yeah, it is something that people can do now. I'd like to just raise a point with Dame Judith, which has concerned me, because I was very optimistic when I received the draft report and then the final report, and it's about your hope, James, that the industry itself would come together to start sorting things out. My experience has been that that's not taken place. That my experience has been that, for example, agreeing on competence of fire risk assessors, that just hasn't taken place within the industry. That there seems to be reasons not to do that. Whereas for me, it's a fairly simple process. What we've not got any clarification on competency at the moment. And that's 6 and nearly 7 years on, and I'm disappointed in that. I wonder if you have monitored that since you suggested it.
Certainly have. One of the things I've been doing for the last five years or so has been chairing the Industry Safety Steering Group, where we've brought lots of different people in and said, what are you doing? How far are you down this track? And I think every speech, every conference I've attended in the last 5 or 6 years, my main message to people is, don't wait for the regulation, get ready, get started. I guess I see a slightly different picture from the one you're painting, Warren, in as much as I think we do have agreements on what competence looks like. I think that a huge number of people have put the work in to develop those competence frameworks. People like Graham Watts deserve huge credit for hours and hours of work that have gone into all of that, along with all of the people on the working groups. The problem is one of take-up. The frameworks are there, people know what they need to do, but we haven't seen, by and large, the take-up of those competence frameworks in large numbers. But there are some interesting differences emerging, and I think this is what people really need to think about in terms of how are you going to pick the right people to work with, because there are some who are doing it, and there is a differentiation now in the market, I think, between those who get it and are getting on with it and those who are continuing to lag behind and making excuses for why they can't do it, including, well, I need to see the detail of the regulation first, or whatever it might be. The big issue is that there will always be people who come up with those sorts of excuses and who will wait until they feel the force of the regulator, as it were, before they'll act. But there are some good practices out there, and I think we've got to do much, much more to highlight that differentiation point to the good guys, rather than saying that everyone is failing to act.
Yeah, and I just to add to that, Judith, I can't speak on behalf of fire risk assessors, but I definitely, Warren, see some huge improvements for fire alarm engineer qualifications. So previously, when I was an engineer, there wasn't really any formal qualifications. It was a day or a 2-day course. I was a qualified electrician at the time, so I did have that extended knowledge as well. But you see a lot of NVQ level 3 qualifications coming now that not only involve a theory element, but also a practical element. So that's definitely raising the bar in terms of fire alarm engineering competence for fire alarm systems. But I do see gaps as well with other industries and other sectors as well. So there's definitely work still to be done.
I think a better informed buyer, if we call them that, is almost a starting point. And like you're saying, Dame Judith, don't hire someone who hasn't gone through that process. And I'm guessing that's where your experience comes in, Warren, where you see so many people not know the difference between a competent person and an incompetent competent person.
Yeah. I think that's a really good point, and I think that's the thing people need to recognise about the change in the regulatory system. It won't be enough to simply do it. And you'll be asked in future by the new regulator is, how did you know that that person knew what they were doing? How did you satisfy yourself that they were competent to do what you asked them to do? So it's different questions. It's not just a tick in the box to say the job was done anymore. It's how did you know that the person who did this knew what they were about? So you've got to find ways of answering that question just as much as was the job done.
And talking about questions and interrogations, Warren, do we want to deep dive into the enforcement side of this now? Oh, you're on mute.
Okay, I'll share my screen. Now, can you see my slides?
Yes.
Good. Okay, so this is the need to manage and record. I'm just going to go through some figures regarding, well, relating to the number of prosecutions. My figures go to 2022. They're actually published in October for 2023, and I've got them, but I haven't added them to these slides just because of being busy prosecuting and defending. But I can give you a flavour. So these go effectively from 2009 to 2022, March 22. So why 2009? Because the government didn't record statistics until 2009, but I've recorded mine because I'm a bit of an anorak since 2006, and so I can just give my I can add my figures to it, and I think that as of 2022 there was about 840 prosecutions. I suspect that there would be around about 40 or 50 more in the last year that would be added to that figure. Looking at the types of premises that have been prosecuted, it's surprisingly the single most often prosecuted premises are shops, which I find surprising. But I think this is because this involves shops with living accommodation above, and because my experience of 240 cases is that shops on their own and of their own merit have not really been prosecuted because there's not a risk of death or serious injury to the people who use shops. So my feeling is that that's so high because it involves commercial premises on the ground floor and living accommodation on the first and second floors. But you can see HMOs, hotels, nursing homes are in there in others. I know that a third of all premises that have been prosecuted have some element of living and sleeping accommodation, and that's borne out there by the HMO figure, 26%. Multiple use is what I use to describe. These are my statistics. So multiple use, I would use the phrase multiple use to describe shops with living accommodation above. You can see there quite a large one is 7.9%, which is nursing homes. And I think that's because most nursing homes are not purpose built. Most nursing homes are buildings which were not built for that reason. They've had to be knocked about a bit, which means compartmentation issues, evacuation issues, etc. So nursing homes is quite a high one, and I think there was a couple of years ago a real concern from fire services in relation to nursing homes. Hotels is a figure that I think will be growing. It's certainly in the first 10 years of prosecutions, I had a few, but not many. Now I'm getting more and more prosecutions involving hotels. What kind of who are the fire services that are the most prevalent at bringing prosecutions? You can see there the West Mids were very proactive in the early years of prosecutions. Greater Manchester also, who I acted for in the from 2008 to 2014. Greater London, like London Fire Brigade, Lancashire Fire and Rescue Service, done quite a few. Cheshire, I know, have done quite a few. In North Yorkshire, the Yorkshire Fire Services, very proactive. But you can see there from the league table, as it were, that West Mid's done far more than any others. Greater Manchester and Lancashire, effectively, the big fire services who've got the resources to bring these prosecutions, and they are heavy on cost and heavy on personnel use. So it really does need a big and well-funded fire safety department to bring these prosecutions. What's interesting, and I've not put it on there, is that the fire services that haven't done any prosecutions or have done one or two, which in 15-16 years, it just clarifies that it is a postcode lottery as far as enforcement is concerned. Yeah, there are a large number who have done probably one or two prosecutions in the time. Just about what kind of charges and what kind of offences are prosecuted. There's 374 under Article 9, which is the risk assessment, and the risk assessment aspect is where it all starts. It's where we look at premises to say, right, but what does fire safety mean as far as these premises are concerned? And those from government statistics. As far as my statistics are concerned, the most common is Article 14, which deals with escape routes. But Article 14 deals with everything involving escape routes. So it could be doors onto escape routes. It could be distances, travel distances to place of safety. It could be lack of signage on escape routes, lack of emergency lighting on escape routes. It could be a locked door at the end of an escape route. But because you can breach Article 14 in all those different ways, that's why it's probably the most common charge that arises. Article 8 is general fire precautions, but is probably used more often than not in relation to compartmentation and fire separation, because of the general fire precautions which are outlined in Article 4, which is about fire spread. And Article 8 is the only article that deals with that. Article 9 is risk assessment. Article 13, fire alarms. And that can be having no fire alarm where premises require them. It can be having a fire alarm which is not the appropriate fire alarm, but most often it's about the fire alarm not working, as Jason touched upon earlier. Article 17, there is number 5, which is the maintenance, and what again we'll talk about in more detail later. But Article 17 is about having the things there but not maintaining them, and that is a very frequent charge. As I said earlier, 1/3 of prosecutions involving sleeping accommodation, and that is because there has to be, for any offence under the fire safety order, usually a risk of death or serious injury, unless it's a breach of a notice. And really, I think, shows that the fire safety order has been used really in place of Housing Act legislation, and that is as a result of housing authorities preferring the fire services to take the lead, in my experience. So really those prosecutions should be brought by housing authorities rather than the fire services, but that's the way the order has been enforced. And these are my statistics, because there are no government statistics on fines as far as I'm aware. My case is, as at 2022, £1,737,000 in fines. Costs, 868,000. Average fine per case, £14,000. 14,000. Average costs order, £5,677. So these are expensive to defend, and where you are charged with these matters, there is a risk of prison, and there are very expensive. Your own legal costs aren't put on that slide. So your own legal costs, cost orders, and fines mean that you're paying tens and tens of £1,000s for non-compliance. That is out of date, the highest fine to date, because there was a fine in 2023, I think, for over £900,000 for a breach of fire safety regs. This is an interesting slide because it shows the average fine that I've recorded between 2006 and 2013 was average fine was 6,507, and then it jumped up to 20,000 between 2014 and 2019. Post-Grenfell, £53,000. That's the difference that Grenfell has made as far as judges are concerned and their approach. Huge increase now in the seriousness and the way that the courts treat fire safety. Put simply, before Grenfell, I used to have to tell the court what could happen in premises such as these with numerous breaches if a fire occurred. After Grenfell, I don't need to go through that anymore. People saw that morning what could happen, and it didn't need any further. It doesn't now need any further explanation in court. I'm just going to go through a few cases where it shows who can be culpable. The case of Holt is an HMO, effectively, owned by somebody who had a large property portfolio, who employed a management company. There was a management agreement in place for the management of that HMO. There was a fire, and the fire alarm had no power to it. 2 residents had to be rescued from a first floor window. When the fire service carried out their inspection, numerous fire safety breaches were found in relation to compartmentation and in relation to fire doors, and obviously in relation to the fire alarm having no power. The prosecution there was against both the owner of the house and the management company. The management agreement was 2 pages long, and the first page had all the details of the parties. The second page had the management responsibilities of the management company, and it was silent as to fire risk management responsibilities. It effectively said carry out repairs and maintenance if and when necessary. So it didn't mention the word fire at all. So of course, when you come to see who is responsible under the order, they say, well, what does the management agreement say? It doesn't say anything at all. So who we prosecute both parties. They've not established or discussed between them how we're going to manage the fire safety in these premises. And there is an example of, well, then we have to prosecute both of you, because Article 22 requires you to cooperate and coordinate to make sure the premises comply with the fire safety order. A London Fire Brigade prosecution against someone whose initials are JZ. Now, he was someone looking after premises whilst the owner was abroad for about a year. And he had no contractual relationship with the premises whatsoever, but the tenants contacted him if they had any problems. He was the one who gave them the keys to the premises. He was the one who they contacted if they needed anything doing. And they did in fact contact him because there was no fire alarm in the premises, and it was just after Grenfell, and they were in London, and they said, why shouldn't we have a fire alarm in the premises? Because there was a Chinese takeaway on the ground floor, and there was living accommodation on the first and second floors. He was found guilty under Article 5 on the basis that he had control of the premises, and he was on the basis that He was liable to the extent of his control. He wasn't the responsible person. He was the person just effectively looking after the premises, and the court said, no, you're responsible. A prosecution against another management company, an individual at that management company, and a fire risk assessor, Denford's and others, a block of flats, fire service inspection, and effectively prosecution taken against all the people involved who did not put the fire safety management into place and carry it out. So that was the management company, that was the fire risk assessor, and actually the individual in the management company who had power and control over that particular premises. There's one where CFS where that effectively was an investigation, not a prosecution, because they were involved with the fire detection and the venting system that was attached to it, and that was an investigation that took place. But because they didn't have a maintenance contract, they were effectively brought in as and when. The prosecution could not be taken against them because they did not have overall responsibility and control over the premises. And then the final one, LFRS in Goffin, that was a working men's club where there was a company who was the employer, so the employer would be the responsible person, and there was a designated premises supervisor, Mr. Goffin, who was responsible for the bar, and his mother, who effectively said in an interview that she was responsible for the fire safety in the premises. Her son was 22, I think, so quite young to have that kind of responsibility. In fact, the premises had been heated by LPG cylinders. Someone decided to see whether or not there was any gas escaping from them. There was, in fact, gas escaping from them, so it blew up and 2 people lost their lives. And prosecution taken there against Mrs. Goffin, who, although had no contractual relationship to the property, was not a director of the company, had said, yeah, I was the one responsible for fire safety. She was sentenced to 8 months imprisonment. Mr. Goffin got a suspended sentence as being the person who failed to get everybody out of the premises at the appropriate time, and the person who'd not looked at the escape route and the exit doors, which were jammed shut and locked shut, so that when people tried to get out, they couldn't because the doors were locked and bolted closed. So there's just some examples of how and who is responsible under the order. Just going to go through, just for clarification, who could be responsible under certain scenarios. Scenario 1, an HMO, multiple occupancy, numerous breaches of the fire safety order. Owner might take 90% of the rent. Managing agent takes 10% of the rent. Who's the responsible person there if there's a managing agent for the premises? Management agreement makes no mention of fire risk management responsibilities. So who's the responsible person? Is it a workplace? No, it's an HMO. So there's no employer present. So Article 3B of the fire safety order says it's the person with control in connection with the business. The owner still has some control. What about the managing agent? Got a contract for maintenance, liable under Article 5.3. Liable to the extent of his obligations, and Article 22, which says we've got to cooperate and coordinate to make the premises comply. This would be a nursing home. Apologies for my naming of the nursing home, Dunbury Care Home Limited. Fire alarm engineer, Mr. Alarm, apologies again. Who's going to be responsible there for numerous breaches? Who's the responsible person? Is it a workplace? Yes, it is. It's a nursing home. There are staff. There's an employer. The responsible person will be the employer. The company runs the home and pays the staff wages. They're going to be the responsible person. What about the fire alarm engineer? Now, there is a contract for the maintenance of something on the premises. Liable under Article 5.3. Yes, liable to the extent of his obligations to maintain the fire alarm system. And then finally, a kebab shop and flats. Numerous breaches of the fire safety order in the ground and first floor. Owner of the premises, Property Developments Limited. Kebab shop, Mr. Donner. Sorry, I don't know why this is not carrying through the type. Is it a workplace? There is, but only in respect of the ground floor. So we're going to have 2 different responsible persons here, because the employer would have control of the workplace, which is the kebab shop. But what about the living accommodation? Well, that's the property development company, because they've placed a tenant in unsafe premises on the first floor. So those are just who can be responsible, but looking at the framework that we've talked about earlier in the Building Safety Act came into force apart from the competency issue with fire risk assessors on the 1st of October 2023. And the purpose of it, to improve cooperation, coordination between responsible persons, increasing requirements in relation to the recording and sharing of fire safety information, to establish, I think, what Dame Judith was talking about, that golden thread of information from design, construction, and then really important to the management of the premises once occupied. So we've got those continual records that are recorded and now passed on to the appropriate people. These amendments should make it easier for enforcement authorities to take action. I think it will make it easier, and it also ensures residents have access to comprehensive information about fire safety in their building. And that, I think, touches upon what we talked about earlier, which is the end user and the buyer of these services actually being educated to know what questions to ask. If they're now provided with this kind of information, they're going to be more educated to ask the right questions of those that are managing the premises. So rather than go through all of the amendments, I put a slide together which just effectively splits the premises into three types. There's all premises that the amendments apply to. Certain amendments apply just to domestic premises, and certain amendments apply to high-risk premises. And effectively, across the board, it's this requirement to record. It's this requirement to be very clear on who has certain responsibilities. And domestic premises, so that all the information of relevant fire safety information now got to be passed to the tenants. Somewhat draconian, but necessary, in that, you know, we know that tenants are transient, and therefore there may be new ones all the time. They're going to have that information. Cooperation with accountable persons, that's people with the overall responsibility for the premises. So anybody involved with the fire safety got to deal with the accountable person. Just look at it in more detail in respect of all premises. There's now the requirement to record the FRA, the fire risk assessment. That was really always there, but if you had fewer employees than 5, then you didn't have to write it down. And here's a big one for me, that Article 11 requirement to record a plan of action to reduce hazards and risks identified and implementation of necessary protection measures. That has got to be recorded. That's about ownership of management going forward and actually detailing who is going to do what as far as fire risk management is concerned. Information to other responsible persons, and part of that involves outlining, each responsible person outlining the bit that they think that they are responsible for. That's really important, and that now that has to be recorded. So effectively, one person to another, these are my responsibilities, this is the area I'm responsible for. Please tell me what you consider yourself to be responsible for, and that should open up the discussion and remove any lack of clarity about ownership of responsibilities. And again, relevant fire safety information, and this really is the golden thread point as far as I'm concerned, Regulations 38 information. So all of that information about the build, design, construction needs to be passed through to new responsible persons, those managing the premises. And again, must keep records of the relevant fire safety information. I've just highlighted the bit below that, which is Article 5.1, which is in a workplace, the responsible person must ensure any duty under Articles 8 to 22b is complied with. And that just goes again back to what we were talking about with relation to the responsible person is ultimately responsible for all of those responsibilities, even if they have been delegated. So they have to ask the questions, do you know what you're doing? What is your competency? What is your experience, etc. In a workplace, that's going to be a strict liability, and it is a strict liability responsibility. It applies to non-workplaces, but that's a responsible person, very often a landlord, who, to the extent of their control, it's not strict liability for non-workplaces. So that's just a very quick outline of culpability, accountability, and how the new framework will affect that.
It's brilliant. Thank you, Warren. I did have a question that the audience might benefit from knowing. Of those cases, how many of those cases were there a fire incident in that provoked the prosecution? And then secondly, how many of them resulted in loss of life?
Okay, well, I think a bit more specific than that. I can go back to my. Sorry, I've lost. I can stop sharing now. I can go back to 240 cases. I think there's a fire in about no more than 15-20%.
Wow, right, okay. So in essence, it doesn't necessarily a fire event or a loss of life doesn't necessarily trigger a prosecution. We're which is great to hear, because we're catching it before anything happens.
Yes, the majority of fire safety inspections, which are either led on a type of premises basis, on a risk-based sort of priority basis, or a complaint from the public. But usually no fire. Loss of life, thankfully, not that many. I think in my cases, again, probably 3 or 4%.
Brilliant.
Yeah, it definitely makes you feel a certain way when you hear small lapses of judgment causing a loss of life.
My experience has been that
sobering.
it's not. My experience has been that it's not usually a small lapse of judgment. Dame Judith used the Swiss cheese model. There was a phrase that I heard once, which was, for a catastrophe of that level, all the stars have to be aligned, but in the wrong way. But the Swiss cheese model, you could see all the holes; they had to be aligned, and so it's usually not one person or one slight error of judgment. It's usually a catalogue.
Well, with an average fine of £50,000, whether or not you're somewhere in the country where enforcement is kind of like high priority and invested in or not, you don't want to take that risk categorically, systematically across your entire organization. And all your employees need to know, if you're an employer, that everybody in the organization is a target if you're involved in the fire safety. Jason, do you want to bring it home? Unless Dame Judith, Jason, do you have any more questions for Warren to discuss? Bring it home with some real advice on how people can actually, put this into practice and take back control of fire safety, because this has probably raised a few alarm bells.
Absolutely. So I've got a couple of slides to share with everybody.
Just to pause you, your head is very large. If you just share regularly, that would be better.
There you go. Let me unshare here. There we go. Is that okay?
Yeah, brilliant.
Brilliant. So let me get the slides. So what I'm going to be closing with is how we need to start empowering the responsible person, how giving that person the right tools, they can then identify and remedy issues before they start compounding into larger, unmanageable enforcement and safety problems. We're going to be looking at tackling indifference, so balancing speed and costs, and then obviously taking accountability, the role of educating the responsible person beyond fire warden training. So as mentioned earlier, there's some excellent advice on the government website. This is an article that's published by the Home Office, which gives a guidance on who's responsible for fire safety in a building. So like Dame Judith said, there's some great content out there, and it really is simple. I just wanted to highlight on this document that it basically suggests that if you're working in a hotel chain, a retail chain, or a limited company, then ultimately the company is responsible. But if you do have a general manager or a store manager, then they will have responsibilities and duties for fire safety in their workplace. We'll send a link out to download that piece of information, but it's really useful. So how many people are we talking about here? So the current government statistics from 2022, they show that there are over 2.1 million non-domestic properties in the UK. So theoretically, if each of those properties has a responsible person, that's 2.1 million people that are responsible for fire safety in their workplace. So I'm going to be looking mainly at Article 17. Obviously, being a veteran fire alarm service engineer, maintenance is my field of expertise. And what Article 17 says, if I highlight the bit at the end here, it says that the system you have, they're subject to a suitable system of maintenance and they're maintained in an efficient state and in efficient working order and in good repair. So I just want to touch on that. So we've got 2.1 million responsible people in non-domestic premises. So what responsibilities do they have other than ensuring that the systems are in working order and good repair? So the first part of the responsibility is to hire a competent person or company to service your fire safety equipment. And as we mentioned earlier, this is an example of a matrix of responsibility. We'll put this as a free download to everybody in the audience. Essentially, what you've got on the left here is the type of equipment. Then we've got the type of task that needs to be carried out, whether that's a service task, a review of the risk assessment. Then there's a column in the middle, so you can sit down with other responsible people and work out who is ultimately responsible for that particular task. And then on the right hand side, we've got the frequency of the task based on the relevant British standards. That's the minimum frequency. So that's job number one done. What I often hear is this sort of statement here. So, Jason, I've hired a contractor to check my fire alarms every 6 months, and I've also got a copy of an up-to-date fire risk assessment. Have I fulfilled all of my duties as a responsible person under Article 11 and 17 of the RRO and the Fire Safety Act? Unfortunately not. So there is little point having your equipment maintained once a year or every 6 months by a service engineer if the remaining 364 days of the year, no one else is checking it. If no one else is checking your equipment, how is that ensuring that your fire safety equipment is in efficient working order and good repair? So step one, yes, hire a contractor. There are more responsibilities that you need to carry out. So there is a second matrix responsibility. So this matrix responsibility is again taken from all the relevant British standards, BS 5839 for fire alarm systems, BS 5266 for emergency lighting, etc., etc. Exactly the same format, but you'll notice the checks are on a more regular interval. So not only are we doing things every 6 months and every year, we'll also need to do checks daily, nightly, weekly, monthly, quarterly, 6 monthly, and annually. So again, same sort of format. Ensuring obviously your equipment is checked on a regular basis, so not just every 6 months, not every 12 months, will ensure and prevent issues from compounding and costing your business more money. So for example, if a member of staff is inspecting the fire doors in a non-domestic premises and they're doing that every month and they spot, I don't know, a hinge with a couple of screws missing, that can be remedied quite easily. If that's left to compound, that door could then become ajar. It could damage the frame of the door, it could damage the actual door itself, and that could result in the whole fire door needing replacement, which will cost your business a lot more money than just replacing the screws. All of the checks you see on the screen here need to be documented, apart from the daily checks, unless you spot an issue. So the next thing I want to talk about is, so where do I record them? Because it's excellent if you're doing these checks, but if you're not recording them, you might fall at the final hurdle. So don't fall at the final hurdle. Do the checks that you're meant to be doing, fill out the matrix responsibility, understand who's doing what, and you should record all of your tests in a fire logbook. And I think everyone on the webinar will understand what a fire logbook is. Unfortunately, there are lots of issues with fire logbooks, so try not to fall over here. So I see, and my experience of a fire logbook is that they're duplicated, they're incomplete, they're lost. They're hard to read. I'm a left-hander, unfortunately, so when I write with a biro, I do rub out all the ink. They're incorrectly stored, so I've seen fire logbooks stored in the fire alarm panel itself next to the power supply, and these power supplies get hot. So in fact, you could be causing a fire hazard just by where you're storing your fire logbook. So don't fall at the last hurdle. Make sure, ultimately, make sure that obviously all the checks are documented, because that will help prove your due diligence. The next thing that often I get asked is, well, Jason, I don't record my fire checks in a paper logbook. I record all of my fire safety checks in a CAFM system, so a computer-aided facilities management. So what I've done is I've removed all my paper logbooks from my building. Is this okay? It's a question I come along all the time, especially with larger organisations. Now, in BS 5839 Part 1 2017, Section 48.2, there's a note that says the logbook may be kept in an electronic form, but it must be accessible for all interested parties. And what it means by accessible is that you can't have a system on the cloud or in a CAFM system that can't be easy accessed by those individuals who need to access it. So for example, you can't have the fire rescue service coming into your building, asking to have a look at your fire records and your fire logbook, and then you have to give them a login to your system. You have to train them on how to use your system. And then when they get a login and they get into the system, it's not in a format that they easily recognise. So in the British standards, it doesn't mention CAFN systems, it doesn't mention spreadsheets. So if you are considering removing your paper file logbooks, you need to implement a solution that is compliant with that clause in the British standards. The next area of concern is around secure information boxes. So I get asked a lot of times. I'm installing these secure information boxes in all my buildings because I've been told I need to under Regulation 4 of the Fire Safety Act. Some of the buildings that I've seen these being installed in are self-storage businesses. They're in offices. They're in single-story environments. Some of these companies or some of these buildings, they don't actually have an update fire logbook and up-to-date fire records, but instead they're spending thousands of pounds, potentially of business costs, of taxpayers' money that could be spent elsewhere. The secure information boxes should only be installed in buildings that are in scope. So the sort of buildings that would be in scope, and again, there's loads of information on the government website on this, are residential flats over 18 metres in height. You've got any new residential flats that are over 11 metres in height, any residential buildings with a complicated layout, you've got student accommodation, and then you've also got other student accommodation that is more than 11 metres in height. So these are the sort of areas that you should be installing a secure information box. You shouldn't be installing them in office environments and businesses like that. The other issue that we tend to find is that the purpose of the secure information box is to provide the documents to the fire rescue service. And that's so that in the event of an emergency, they've got access to the relevant plans of the building. They can see where the dry wet riser locations are. What's not meant to be stored in the secure information boxes is your maintenance records. So your fire logbook, that should not be stored in there. It's not for the event of an emergency. So if you are concerned that your paper file logbook might go up in flames, rather than putting a secure information box in, then you should obviously consider looking to move over to a digital platform instead. And then I've got two other points before I close. So the next off the question I often get asked is, Jason, my employer has asked me to assist in the responsibilities for the fire safety in my workplace, and he's put me on a fire warden training course. You know, is this enough? Is there anything else I can do to improve my competence? So fire warden training is excellent. It's designed to train staff how to prevent fires with good housekeeping. So it teaches them about switching electricals off, not storing combustible materials next to ignition sources. It shows them how to do fire evacuations. Often it'll involve practical training. So it will show you how to use a fire extinguisher. And there's science-based training as well around the fire triangle. So it will teach you fuel, oxygen, heat, etc. Unfortunately, fire warden courses do not show your staff how to correctly conduct the daily, weekly and monthly visual checks on your fire safety equipment, like fire alarms, like extinguishers. So imagine your fire warden, they've been trained, they pick up a fire extinguisher because there's a small fire in your building, they try to tackle it and the extinguisher's empty. That's because it's been tampered with, no one noticed because it hasn't been regularly checked. So like the Swiss cheese model, it's important that not only doing fire warden training, that we're regularly checking the equipment as well. When I was an engineer, one of the important parts of my role and what I really enjoyed is when I would hand over a new fire alarm system, I would then show the customer how to correctly test that system. So we provide them with the keys, we provide them with a logbook. And unfortunately, staff move on. So, the member of staff that I might have trained might have moved on to a new business, and skills aren't passed on from one member of staff to another. So people can start slipping through the cracks. So if you are concerned about this, I'm really proud that very recently I've been involved in creating the first free online CPD training course. And that course specifically teaches responsible people how to correctly test and inspect their fire alarm, their extinguishers, their emergency lights and more. So the daily, weekly, monthly checks that are crucially important for that Swiss cheese model, your staff can get free training on how to do those, as well as the fire warden training. And the aim of that is to educate and empower the responsible people across the UK. And if we give them the tools and the knowledge that they require, to carry out this vital role that will obviously raise the bar in fire safety. And then the final slide is one that I often hear, and it's the case of insurance. It's you know, I've got insurance, so if there is a fire in my business, they're going to pay out, so I don't really need to worry about fire safety checks. Unfortunately, that's when we look at the stats. So there's the Association of British Insurers. There's a trade association. There's over 400 insurers in that group, and basically between them, they write about 91% of the insurance for the UK. They've done a memorandum, and they published that on the government website. And basically, it was revealed that even after an insurance payout, many businesses never completely recover from the fire. They lose their regular orders, they lose key staff, and 90% of them go out of business within 12 months. So as a business person, it's a pretty bad strategy just to rely on your insurance. That's why it's so important that you have the people trained, the responsible people in your company are shown what to do, and equally that those people are doing the checks they're supposed to be doing, but they are correctly documenting those fire safety checks in your logbook. Thank you very much for your time. That is all my slides. Were there any questions?
I mean, that's very insightful. I think all of us smiled a bit when we saw the insurance slide, because it's an interesting situation. I don't know whether, Warren, you have any insight into this. Like, if someone had an issue in their building related to fire safety, does that kind of just remove their chances of getting paid out by the insurance company? Because they're like, oh, well, you were just prosecuted.
If they were prosecuted, I think it would pretty much rule out any claim. If you've not complied with something minor, I'm not sure it would, but yeah, the insurers would be looking for you to do all that was necessary to make sure you did comply with the fire safety order, and if you didn't, you may have problems with claims.
Yeah, and Jason's really talking about, you know, documentation. I think that was a key point of your talk as well, Warren, where you can do the checks, but at the end of the day, if there's no evidence of that due diligence, you haven't got the best chance of kind of getting yourself off the hook as an employer or as an employee within the organization. Is there any further comments that we can talk about when it comes to documentation?
Well, up until October, you weren't required to record those matters, and now you are. And whereas previously it would have helped you to be able to rely upon the recording of those things, now you've got to pretty much record it, and so not having it is in itself a breach of the order. It's not necessarily an offence, because just by not writing something down doesn't mean you're going to put people at risk of death or serious injury. However, if you've not provided information to certain people and then they've suffered injury, etc., as a result of that, then yeah, that would be something that would be prosecuted, and it would be an aggravating feature.
Then Judith, do you think, going through the enforcement, the amazing insights from Warren on the enforcement and then the practical advice from Jason, does that feel like a pragmatic approach to raising the bar when it comes to your thesis on, we're putting in these reforms to encourage people to do a better job, not just scare them?
Absolutely. Do I think it's I think in any system like this you need carrot and stick. And to see the way that the fines have risen since Grenfell is actually really encouraging to me, because prior to that, the level of deterrent was ridiculously low. So to see that increase in the level of fines, I think is absolutely right on the deterrent side. But I'm still hopeful that we can appeal to people's better nature to do this for the right reasons, rather than to avoid getting taken to court.
Yeah, I agree. Well, I feel like we've actually run out of time. I apologize for anyone who's posted the question in the live chat. I promise we will get back to you over emails, and we will post some of your questions online as well in other places and share that all with you. From me, from Tio, I'd like to thank all of our guests here. Everything that they've shared when it comes to guidance towards information on the government website, we'll link it all, we'll send you an email with as many documents as possible. I think that matrix of responsibility and having you guys in your organizations get that document signed and approved by everyone, we'll make sure to give you a template that you can download and kind of get started in that process as soon as possible. And of course, training is always available. A link with that of that will be available too. So I'd like to thank all of our guests. Thank you very much. And any final comments, any final goodbyes before we head off?
No, all good. Thank you, Judith, and thank you, Warren. Really, really informative, and I'm sure the audience will love the webinar.
Thank you all, and see you soon.
Bye.
Thank you.
Bye.